The moment you get your EB1A approval, it feels like a huge relief and the beginning of a secure future in the US, right? But lately, there's been a lot of concerns floating around online. Can an approved EB1A petition be taken away? Unfortunately, the answer is yes. But before you panic, know that not every EB1A case faces revocation. In fact, I haven't seen one that has. So, what could cause this revocation overall? A lot of people ask. Hi, I'm Simon Shetty, your host and the founder of the Smart Green Card program, and in today's video, I'm going to walk you through the potential reasons why some EB1A petitions may get revoked, and most importantly, share what you can do to prevent it from happening by following all the best practices that you can. Let's get straight into it. But before we get in, I want to make a note that we are not immigration attorneys. I am not a lawyer, so this is definitely not legal advice. Smart Green Card program does not represent you in front of government. We do not give any legal advice. So for all sorts of legal advice, you should definitely consult a US licensed immigration attorney. So with that said, let's dive into it. Number one, withdrawal of petition from an employer. So if you filed your EB1A through your employer and they request you to withdraw your approved I-140 petition, it is important to know that USCIS will revoke your application if it has been approved for less than 180 days till that date. But if your I-140 has been approved for 180 days or longer, USCIS typically won't cancel your petition, even if your employer asks to withdraw it. In cases where your I-140 is approved and your I-485 has been pending for 180 days or more, you can feel more secure because USCIS will generally not cancel your EB1A petition, even if your employer requests it. To avoid such issues, all of our clients have self-petitioned their EB1A green card applications and successfully obtained their EB1A approvals, because self-petitioning just removes any remaining dependency from your employer, and that is the sweetest spot that you would want to be in. Number two, failing to continue working in your field of expertise. One important aspect of the EB1A is demonstrating your commitment to your field of expertise. If USCIS somehow finds out that you are probably not actively working in the area of your extraordinary ability after obtaining your EB1A approval, they might revoke your application. Again, I haven't seen any of these happen myself, and we've helped so many people out there, but this is a potential reality. And this is where it becomes very important to build your EB1A profile in the field that you are in. A lot of people kind of make up stuff, they make up achievements, they make up their field of endeavor, which you should definitely not engage in. Your EB1A journey should be an organic progression of where your career is taking you. And if you do so, there is no way that you will be doing work later on that is completely different from what you got your EB1A for. In addition to that, you can consider publishing research papers. You can continue to do that. You can continue to review the work of others, even publishing a book in your field maybe, because once you are a thought leader in the space, all these opportunities keep coming to you for you to pursue them. And this continues even after your EB1A approval. This not only proves your intent, but it also keeps you connected to your passion and your community as well. Number three, misrepresentation or fraud. And this is a big one. If you have submitted any false information or fraudulent documentation and USCIS finds out, they will cancel your approved EB1A petition. So definitely don't go in this route. For example, to meet the EB1A scholarly articles criteria, USCIS reviews whether you have authored a paper published in major publications. If you have submitted outsourced articles and if you have misrepresented that you wrote them, it is considered as fraud. If USCIS discovers this, this may lead to serious consequences, including revocation or even maybe a lifetime ban from the US. And this is precisely the reason we tell our clients that at Smart Green Card, we do not write the papers for them. We give them all the support that they need to find the topics, to see how to write the papers. We review the papers, give them feedback, but we want them, our clients, to be the people finally writing the papers, because that's very important. We cannot be creating your scholarly material for you for this reason. And we've had numerous people come through the program and ask us to write their papers, and we've constantly declined that because we want you to do things ethically and not face any repercussions later on. Also, you should always provide accurate and honest information for your EB1A case And that brings me to number 4. USCIS procedural errors are also part of this. USCIS may cancel your approved EB1A petition due to some internal errors or misrepresentation of your qualifications. But this happens in very, very rare cases. So, does USCIS really notify you before a final revocation? Well, when USCIS revokes a I-140 petition, they typically send you something called the NOIR or the NOIR, which is basically the notice of intent to revoke. And this is basically your chance to respond and clarify any issues or concerns they might have had about your petition. But there are times when a petition is automatically revoked without any notice, and this can happen due to specific events like the death of a petitioner or the beneficiary, or even changes in circumstances that make the petition ineligible at that time. Plus, if USCIS discovers that a petition was obtained through fraud or misrepresentation, they may revoke it even without issuing a notice of intent to revoke. So, if you receive a NOIR, it is crucial to respond within the given time frame, which is usually 30 days. You should use this opportunity to provide additional evidence or arguments that address all the USCIS's concerns. But more importantly, you should be proactive in your response, and for that, you should definitely see a US licensed immigration attorney to seek legal advice from them. So what if your EB1A petition gets revoked now? If your I-140 petition is revoked, you generally have the right to appeal that decision. You can do this within a specified timeline by submitting the new evidence or arguments to challenge that revocation. And it is a good idea generally to consult with an attorney who can guide you through this process and help strengthen your case in that regard. I hope this video helps ease your concerns regarding EB1A revocation rumors. There's a lot of them circulating around, although I haven't seen a single revocation until now. So if you have done everything right, ethically, legally, and have represented yourself really well to the government and accurately to the government, truthfully and honestly, I don't think you should be worried about any of these consequences at all. But while going through your EB1A journey, it is very important to make sure that you do every single thing ethically. There are so many ways for you to build an EB1A profile, and you better do it in the most ethical and legal manner that you possibly can. Join us on this YouTube journey for daily insights into the EB1A process. Subscribe to get step-by-step guidance in achieving your EB1A goals. Thanks for watching until now, and until next time, this is Simon Shetty signing off. Take care and peace.